So, good afternoon, everyone. Today I'll be reviewing the movie A Time to Kill. So, basically, A Time to Kill is a compelling and intense thriller based on John Grisham's first novel. The movie is about an African American man convicted for murdering two white men who has raped his daughter and almost killed her, and his defense lawyer who goes against all the odds to save him from the death penalty. That is, Carly Haley, to save Carly Haley, the defense lawyer, that is Matthew, goes all the length to all the odds to save him from the death penalty. So the theme of this movie is mostly vigilantism, racial discrimination, and lack of faith in the judicial system. The role of Carly is played by Samuel L. Jackson, and he is the avenging father. And the role of lawyer is played by Matthew, and the name of the lawyer in the movie is Jack Brigance, a young, sharp, and witty but inexperienced defense lawyer. The relentless and untiring determination towards his commitment to seek the justice is a lesson that all the young lawyers should learn. So, moving on to the legal aspect of the movie, that is the legal issues posed by the movie. So basically, there are several legal issues that are posed. The first is, can someone be allowed to take law into his own hands? The second is, the main bone of contention over the years in the field of law is that there is a distinction between justice and deciding it in accordance with the law. The justice is a different aspect, and deciding it in accordance with law is a different aspect altogether. So in this movie, the idea is that will a black man receive a fair trial in the South? So before I also answer all these questions, let's take the first and the foremost question of uh, that is how to prove insanity. So this movie basically revolves around how to prove insanity in the whole trial process. So I'll take on the issue of how to prove insanity. So in the starting, I like to quote the legal maxim: "Actus non facit reum, nisi mens sit rea." That means that an act does not make anyone guilty unless there is a criminal intention or a guilty mind. So in this movie, it was tried to prove that he didn't have guilty mind because of his insanity. So let's give this issue an Indian perspective. Let's start with Section 84 of IPC. So Indian Penal Code give defenses to criminal liability under Section 76 to 106, and Section 84 is specifically to insanity. The section quotes that nothing is an offense which is done by a person at the time of doing it by reason of unsoundness of mind and is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to the law. So on reading this definition, there are three essential ingredients to insanity. That is, that the accused should be of unsound mind. Second, that he was of unsound mind at the time he did the offense, he did the act, and not merely before or after the act. The third one is that the result of unsoundness of mind, he was incapable of knowing the nature of the act, and that he was and that what he was doing was either wrong or contrary to the law. So when we see the jurisprudence before this insanity principle or the Section 84 of Indian Penal Code, we know that most of the Indian Penal Code is brought to us by the British law only. British law itself developed a rule that is very crucial to the point of insanity, which is Macnaghten's rule. So I'd like to state the Macnaghten rule here for everyone's clarity. That is, it states that in order to establish a defense on the ground of insanity, it must be clearly proved that at the time of committing the act, the accused was living under such a state of reason that he did not know the nature and quality of the act he was doing, or if he knew what he was doing, he did not know it was wrong. So this is the basic principle or basic rule behind Section 84. So at this point, at this juncture of this review, it is very important that we know the difference between medical insanity and legal insanity. To know the difference between medical insanity and legal insanity, I would like to quote the judgment of State of Maharashtra versus Sindhi. This is a 1987 judgment in which the court was of the opinion that there is a clear distinction between medical insanity and legal insanity. Although medical insanity may be of various kind, degrees, and intensity, to what extent a medical insanity affects the cognitive faculties of a person is what is to be seen. So there may be cases that a person is insane, but he may not be legally insane. So what we need to recognize is the nature and the quality of act, and not just the insanity part. If a person is capable of knowing that what he is doing or he was doing was either wrong or contrary to the law, he will not get the benefit of section 84, because section 84 is not for that purpose. So this raises a question that if a person is suffering from insanity, can we say that he is ipso facto defected under section 84? But this question was resolved by Surendra Mishra versus State of Jharkhand, in which it was pointed out that every person who is suffering from a mental disease is not ipso facto exempted from criminal liability. So unsoundness of mind is used to describe only that condition which affects our cognitive capacity as an individual. So moving on to the difference between, so our law is derived from the Magnoton rule, but it is not as same as Magnoton rule because there is a slight difference. So here we will try to analyze the slight difference between section 84 and the Magnoton's rule. So Magnoton rules refer to disease of mind, while the Indian Penal Code in its section 84 uses the expression unsoundness of mind. So there is a big difference between disease of mind and unsoundness of mind. Unsoundness of mind has a wider scope, and it does not only cover insanity or mental illness, but it also covers forms like deficiency of like idiocy or even feeble mindedness. Like feeble mindedness is something of a less intensity to insanity, so it covers that also. So our section is more broader. So finally, it can be said that India has taken a broader approach to this section. So recently, I done a personality analysis of Darbara Singh versus State of Punjab. He is a serial baby. He is a Indian Army serial baby killer. That is the term I quote for. That he is a serial baby killer from Indian Army, because he was an Indian Army personnel and he was keen on killing babies. So I personally feel that he should have been invoked the section 84 for his defense, but in that case he didn't do so. But his cognitive capacities, according to me, were not up to the mark, and he was not able to identify between right and wrong. So what are the other rules that can be used to establish insanity? So for taking an international perspective, the irresistible impulse test is of value. Even when you know that the act is right or wrong about the nature of the act, but you have no control over it. Recent advances in science and technologies have shown that many insane person may be fully able to know what is right and what is wrong, but yet they do not have the power to control themselves. They can't stop themselves from doing that act. So in India, the main emphasis is given on that the person knew what it was right or wrong. But on taking an international perspective, regions like Virginia and New Mexico has combined the irresistible impulse test with Magnoton's test, thus broadening the aspect of insanity. But this is still to be implemented in India. It is not implemented in India by seeing the previous case laws. On seeing a statistical analysis on how insanity pleas outcome in an Indian High Court, it is seen that only 17% of the insanity claims get acquittal under section 84. So I'll say it is a rather small number, so it is hard to prove insanity. So for a lawyer to prove insanity, like in this movie, there was a lot of emphasis given on the psychiatrist's statement that what he says will be accepted by the jury. But in my opinion, that the testimony of a psychiatrist may be important, but what is more important is the facts of a particular case. So now talking about the movie, when it was said that the child opens the door and he says he is innocent. So I'd like to say, and he went back to his home. This is not the procedure that is followed in India, and I also think it is also not followed in India. So the procedure that is followed for unsound mind people in India is given in chapter 25 of CRPC, and of which section 335 is of more importance to us. Section 335 has two subsections, two clauses or subsections, whatever you would like to say it. The first states there, order such person to be detained in safe custody in such a place and manner as the magistrate of the court thinks. And the second is such person to be delivered to any relative or friend of such person. Like this is the procedure under CRPC. For this, I would like to present something. Share my screen. I have a pie chart for that. How this is done in India, sir? Can I do that?
Yes, please.
So this is a image that I found on some research paper. So when we see to the right of this chart, section 84 is invoked and the person is acquitted. Now there can be two things that can happen. That is, one can go under section 335 subclause 2 or section 335 clause 1. Under clause 1, under clause 2, he will have to be treated, and then the committee along with the magistrate has to give him approval, and then he will be transferred to a civil asylum. So what I want to convey here is that I'll stop the sharing now. What I would like to convey here is that the process that was followed in this movie was totally fictional. This is not how the things in actual legal proceeding happens. Now I would like to move on to the jury trial. The jury that was so emphasized that there was discrimination in jury and the jury was all white. Now let's take the initial questions that I posed. From a legal point of view, the 1875 Civil Rights Act outlaws race-based discrimination in jury system. So the initial Civil Rights Acts of America outlawed that there should be no discrimination based in jury system. And after that, the Federal Jury Selection and Services Act of 1965 ensured that while selecting jurors, there must be a fair cross section of community that is involved. So to understand that there is no discrimination based on race in jury system, there was a landmark judgment by the Supreme Court of US that it gave in Batson versus Kentucky, which states that discrimination violates the equal protection clause of the 14th Amendment to use a preemptory challenge during jury selection to remove a potential juror because of his race. So, sir, we can see that there are many laws to everyone in this class or in this group. I would like to say that there are laws for protection of discrimination in jury, that it should not be all white and a fair section of the society must be used. But there are still lacunas, there are still loopholes. Because I'll show the loopholes now. Because when this Supreme Court judgment was passed, it was passed prospectively, not retrospectively. Then what will be the consequence of this is that refusal to apply the decision retrospectively have meant that scores of death row prisoners have been executed because it has not been applied retrospectively, and the case that have been filed with the jury all white, that people has to follow the rule, which is the rule, because it is not filed retrospectively. Moreover, dozens of condemned prisoners still face execution after convicted and sentenced by jury selected in a radically different manner. Because although the laws are passed, but still there are many research paper and news that the jury is biased toward black people. So here we need to see that although the law is there, but its implementation is rather not perfect. It needs to be perfect, but it is rather not. So the Supreme Court also in a decision in Rose versus Michelle, it has particularly admitted that race discrimination has no place in criminal trials. Discrimination on the base of race in all respects is especially precarious in the administration of justice. These are the exact line that was quoted by the Supreme Court. So finally, we reach to the question that should the law be taken by people in their own hands? I have my own analysis to this part. I think that we as a society in which justice prevails and law and order is maintained, we should not take law in our hand, but we should take a more forward and more broader approach to this. Because if everyone take the law in their own hand, it will be a barbarian society. They will have their own justification for their own acts, but this is not the way forward in a civilized society. So what we need is faster implementation of laws and more strict laws. For this, in India, there are fast track courts, and the and the judiciary is trying for faster implementation of laws. But there is also need for stricter laws, because, like the black people face discrimination in US, the condition of women in India with regards to sexual harassment as workplace and domestic violence is just like that only. Because in a patriarchal society and patriarchal law system, it is very difficult for a woman to come out. but it does not mean that she should take law in her own hand. But we as a society should implement laws more efficiently.
Okay, that's all.
So that's
Okay.
all.
Okay. Thank you, Arpit. Okay, 2 3 points that is regarding that you raised. That movie is fictional. That is the one point. Of course, movie is fictional. There is something like nothing related to the reality. And the second point that you raised, that what is in the practice, that there shouldn't be any discrimination based on the color or race or something like that, because of the law. See, what I observed the law, of course your view is appreciated, but even judiciary, if you see in Indian context, judiciary is impartial and independent. Basically, judges are impartial and judiciary is independent, because the purpose is to do the judgment, to do the justice independently, impartially, and no on basis of no ground, no one is supposed to be discriminated. But ultimately at the end of day, all are human beings, and human beings are born to be biased, honestly. You just take a lot, whatever the precaution, whatever the strict law you're supposed to be applying. And this was the reason that in the beginning we have discussed the de facto and de jure, what law says and what we practice. So there will be discrimination, we can use the term, there will be, and that is bound to be happen. So there is no, means there is no question on that ground, that will remain there. And again come back to, and you very well explained that day the another two terms, that is procedure established by law and due process of law. And you only explained that in United States people practice, basically judiciary practices the due process of law. In India, we do not have that system, due process of law. Rather, our constitution mentions that is procedure established by law. So we have something different. But these days, because of the judicial activism or such kind of things, due process of law that you can also see in Indian judiciary as well, at least in some of the Supreme Court cases. Supreme Court judgment, you can see that. But if we consider the concept of due process of law and then we go back to the movie, then you can very well appreciate the thing that is shown in that movie. Because if you consider this concept due process of law, then law is secondary thing. The first thing, that is the circumstance, the emotional part, the thing that he suffered, his suffering and all, the insanity that is the taken by the defense lawyer, that is only to protect him. That was just camouflage, you can say like that. That was not the reality, that was not the fact. Only to just in order to protect that person, that the term is used. Otherwise he was completely well, because that he planned very nicely to kill, है ना? But if you see the due process of law, the concept, that is very well. And this is the purpose of practicing jury system in India. In India it was there, jury system was there, not very much popular, but happened something wrong in the case of, can you cite the case, can you cite the case?
Sorry.
The state of Maharashtra.
Sorry.
The case of KM Nanavati versus state of Maharashtra.
Yes, thank you, Pooja. That is the case. In Nanavati case, that was. It is believed that jury were basically, they were biased. So after that, jury system is abolished in India. So after that, there is no jury system. So anyway, that's nice discussion. So if you have the work, you may leave. And second one is Hinal.